Good afternoon, and welcome to our program featuring Judge LaDoris Hazzard Cordell, which we have entitled Our Judicial System, Broken but Fixable. My name is Scott Pinsky. I'm the chair of the Marin Coalition, and I welcome you to this program where we will present Judge Cordell as well as the moderator for our program, a good friend of the Marin Coalition, Mr. Noah Griffin. So this is our first program for 2022. I'm pleased to have everyone here. Before we start, let me tell you a little bit about our group. For those who are unfamiliar with Marin Coalition, we are an all-volunteer, nonprofit public affairs forum based here in Marin County, where we strive to present speakers from various perspectives and sectors of the community to create conversations that truly matter. We welcome all viewers, and we continue to present all of our programs online to the public at no cost. I want to personally thank those who have been donors and members for the last year, all of which has helped to make these programs possible and allowed us to continue to do the work that we've been doing here in Marin for nearly 50 years. Next events, March 9, we will be presenting the new general manager for SMART, S-M-A-R-T, the Rapid Transit District. That is Eddie Cummins. He will be on March 9. April 12, we will have Max Corton, the Director of Marin County Parks and Open Spaces, to speak to us about Measure A, the renewal of the open space sales tax. And then May 3rd, a preview of the June primary election, candidate measures and candidates and ballot measures, featuring the A-team from Marin Coalition that we have regularly, Dick Spotswood and Greg Brockbank. Today's event will be recorded and will be available on our web archives at mcmarincoalition.org. That's marincoalition.org. So for today's program, we are extremely pleased to welcome our featured speaker, the Honorable LaDoris Hazzard Cordell. Judge Cordell's recent book, Her Honor, describes her life on the bench, what works, what's broken, and how to change it. In a recent career of firsts, she has broken barriers and at every turn worked to make the legal system more fair, equitable, and effective. Judge Cordell has been a commentator on news outlets such as NPR, CNN, and MSNBC. She is a graduate of Stanford Law School, and she became the first African-American woman jurist in Northern California, a position she held from 1982 to 2001. Prior thereto, she was the first lawyer to open a private practice in East Palo Alto, a low-income community of color. She was the assistant dean of Stanford Law School, where she implemented a highly successful minority admissions program. Following retirement from the bench, she became a vice provost at Stanford University and was appointed the independent police auditor for the city of San Jose. Judge Cordell has overseen commissions investigating violence and mental health care in the jail system, as well as accounts of racism in the San Francisco Police Department. She's received numerous awards, including the Silicon Valley NAACP William E.B. Du Bois Award, the Iola Williams Public Service Award, the National Council of Negro Women's Public Service Award, the Social Justice Award from Legal Advocates for Children and Youth, and the Rose Bird Memorial Award from the California Women's Lawyers Association, in addition to others. Judge Cordell founded the African American Donor Task Force to increase Black participation in the National Bone Marrow Registry. She's the co-founder of the African American Composers Initiative and the California Parks for All. An artist and pianist, she resides in California with her partner and is the proud mother of 2 daughters. Judge Cordell will present an overview of her book, following which Noah Griffin will take the podium as moderator for the remainder of the program, after which we will have audience questions and answers. We're pleased to welcome Judge Cordell to our podium for the first time. Thank you, Judge Cordell.
Children have been neglected or abused, family court cases that include divorces, child custody, child support, and yes, pet support, adoptions, name changes, probate, where people fight over the spoils of their dearly departed, conservatorships, think Britney Spears, drunk driving cases, mental health cases where judges decide if individuals involuntarily confined in locked psychiatric units can get out, traffic court cases, small claims cases, and that's like Judge Judy stuff where there aren't any lawyers. Well, I presided over all of these kinds of cases, and those subjects, those kinds of cases are all mentioned in my book. And there's one other thing about trial court judges, and as compared to, for example, appellate judges. Appellate judges review what trial court judges do. And the appellate judges can take 60 days, 6 months, whatever it takes to sit back and reflect on their decisions. Trial court judges get 6 minutes, maybe, sometimes 60 seconds to decide cases. The pressure on state court trial judges is constant and it's pretty intense. So about the book, Her Honor, I never thought about ever writing a book during the nearly 20 years I was on the bench. So after I retired, I went back east to visit with my parents. And we have an image of my parents, if you want to put that up now. And my mother, both my parents, they're no longer with us, sadly. But when I went back to visit, and this would have been in 2001, my mother, who was a very organized woman, pulls this box out of this closet where she kept her various files. And she said, "What do you want me to do with these?" So let me just backtrack. For the last 7 or 8 years that I was on the bench, I wrote letters to my parents every Friday. And I'm not talking emails, I'm talking letters, like with postage stamps on the envelopes, you sign the letters. And I wrote about everything that happened during that week. And that means the cases I heard, what they were about, the decisions I made. And also I wrote about how what I was doing affected me, impacted me. So my mother pulls this box out and she says, "What do you want me to do with all these?" And she had kept all of my letters. I had no copies of them. I just sent them to my parents and I was shocked. So I boxed them up and I sent them back here to California. And it took me about 2 or 3 years to really read these letters, to start to read them. And I was really stunned by how many cases I'd presided over and the variety of them. So from that, I got the idea of writing the book. So this book is, the purpose of it, there are 3, really: to educate people about our legal system from the perspective of a state trial court judge, to entertain and to energize readers, to fix many of the broken parts in our legal system, some of which I'll talk about today. So I consider the book to be part primer and part memoir, so I call it a primoir. And it is filled with information about these various cases. So I want to start off with how I even got into judging. And it's the first chapter of the book called Bitten by the Judge Bug. So I, at the time, was the assistant dean at Stanford Law School. And I was administrator. I got a phone call from a stranger, and his name is Mark Thomas. He is no longer with us. And he was a white guy. He was a guy who was a judge on the municipal court in Santa Clara County. And he just called me and he said, "We have a judge pro tem program here in our county, and I really want to diversify it. I want to have more women, people of color. Would you agree to go on a list of pro tem judges who would sit for a day to hear a small claims case?" And I really appreciated what Judge Thomas was trying to do. And I said, "Sure, put my name on the list." He did, and then I forgot about it. And then a little bit later, I get a phone call saying, "Your name has come up," because it was kind of a rotating random thing. "Do you want to hear a case?" So I said, "Sure." I go to the courthouse in Sunnyvale. I get a robe. I walk into the courtroom, and what do I see? I see 2 litigants, because there's no one else there. This is just a small claims case. And no clerk, no bailiff or anything. And I walk in, there's 2 litigants, 2 women, and one is suing the other. And the 2 women are African-American. So they looked at me, I looked at them like, what is this? So I presided over the case, and the case was all about hair, H-A-I-R. I'm not going to tell you what it was or what I decided and how it all turned out. That's kind of a teaser if you have not read the book. But as a result of that experience, when I drove home that day, I decided that that's what I wanted to do. I wanted to be a trial court judge. So fast forward 2 years later, I was appointed to the bench in 1982 by then Governor Jerry Brown. And there is you can put up an image now. My investiture, my swearing in, thank you, was done at Stanford Law School, where I had attended, and my parents were there. And you can see my then spouse, I subsequently divorced, and my two daughters, you can see there, who are now in their 40s. And the person who swore me in was Judge Thelton Henderson. That's the next image, if you could pull up. And he went on to the federal court. He had been the assistant dean at Stanford Law School, and I came in after he left, and Thelton became, just a well-known, nationally known federal judge who was my friend and my mentor. So I get sworn in, and I started my work as a judge. Because there are too many subjects to cover in the time that we have, that I've covered in the book, at least 17 or 18 different subjects, I'm just going to focus on three very quickly. Juries, judicial elections, and judicial independence, after which Noah and I can have a conversation and then take your comments and your questions. So start with juries. I presided over dozens of jury trials during my time on the bench, involving all manner of crimes, as well as jury trials in civil cases where people sued each other over money. I love jury trials because I'm a people person, and I saw these trials as a way to introduce people to our legal system in the hope that jurors would have a good experience and feel confident in the system. However, not always, because jury duty is just a very interesting process. I've never served on a jury, but I've spoken to people who have, and maybe some of you have. So jury selection, I found it fascinating, I found it amusing, and I found it annoying when people who saw jury service akin to the plague did their best to get out of jury duty. So it was my hope that jurors would find it to be a positive experience, but I can understand why they avoided jury duty like the plague. So I read from my book, a quick passage here. It is my guess that the answer to why people dread serving on juries lies in the inordinate amount of time wasted sitting around waiting to find out which of those summoned will be chosen. As a consequence, most people come to view jury duty as a nuisance and an inconvenience. It frequently is. Also, it doesn't help that compensation for each day of jury duty is a pittance. Jury fees range from a high of $50 per day, that's in the federal courts and in some states, to $5 a day in some states, and everything in between. California is near the bottom, coming in at just $15 per day, starting on the second day. The first day is not compensated. And when full-time employees are called for jury duty, only 8 states and the District of Columbia require employers to pay their regular wages during jury service. So in the book, I have a chapter called The Fix, where I have 10 suggestions for ways to improve our legal system. And one of the fixes I propose is that states establish jury funds to adequately compensate jurors. And we can talk about that a little more later on if you like. In the book, I note that one aspect of jury selection that is particularly troubling is the use of peremptory challenges. And it isn't only me. In 1989, Justice Thurgood Marshall called peremptory challenges, and I quote from him, perhaps the greatest embarrassment in the administration of our criminal justice system. So peremptory challenges allow each side in a criminal or civil case to excuse potential jurors for no reason at all, as long as they've not been removed because of their race, their gender, sexual orientation, or religion. And each side gets a defined number of these challenges. In California, if you're charged with a felony and you go to trial, each side, prosecution, defense, gets 10 peremptory challenges where they don't have to give a reason at all. So in 1986, the US Supreme Court issued a ruling in the case of Batson versus Kentucky, which I describe in some detail in the book. And basically under Batson, when a defendant contends that the prosecutor's peremptory challenge was racially motivated, the prosecutor has to offer to the judge a race-neutral explanation for removing the prospective juror. And then it's up to the trial judge to determine if that explanation is plausible. So how has that worked out? Not well. More than 30 years after Batson, trial judges continue to accept superficial and outright ridiculous race-neutral excuses from prosecutors for their peremptory challenges. Here's an example that I cite in the book. In 1995, a prosecutor struck 2 prospective Black jurors because of their mustaches and goatee-type beards, explaining, and I quote, "Those are the only 2 people on the jury with facial hair. I don't like the way they looked." The trial judge found the explanation to be race neutral. So when the Batson case was decided, Thurgood Marshall was prescient. He wrote a concurrence in that decision when he wrote this. He wrote, "Merely allowing defendants the opportunity to challenge the racially discriminatory use of peremptory challenges in individual cases will not end the illegitimate use of the peremptory challenge. Any prosecutor can easily assert facially neutral reasons for striking a juror, and trial courts are ill-equipped to second-guess those reasons." So what is to be done? California is leading the way to fixing this peremptory challenge problem. In 2020, Governor Newsom signed into law the Racial Justice Act. And it was legislation proposed by Assemblyman Ash Kalra, who represents the area down where I live and in San Jose. And the Racial Justice Act specifically calls out racism in the criminal legal system. And I want you all to note, I don't call it a criminal justice system because I don't think we're there. We don't have the justice we need to have in our criminal system. And what this Racial Justice Act does is it empowers trial court judges to weed out racism when those, say, for example, peremptory challenges are made. And let's say a defense attorney says, I believe there was racism. The judge listens to the prosecutor's race-neutral explanation, and then it requires the judge to dig deeper. And if necessary, to even stop the trial process, the jury selection process, and hold evidentiary hearings to determine whether or not racism was underlying the decision by the prosecutor to exclude a juror of color. The Racial Justice Act deals with sentencing. It deals not only just with jury selection, and it deals with even prosecutors' decisions to charge individuals with crimes. And again, the focus is to say, we know racism is in the criminal legal system, and it's on us to do something about it and weed it out. Okay, I'm going to move now to judicial elections. As some of you may know, I was able to secure a seat on the Superior Court as a result of a county-wide election in 1988. In my book is a chapter called Judges for Sale, and I describe that experience of running for election. And I describe how the elections of state court judges work throughout the country. If you could show the image of my being sworn in, I won this election in Santa Clara County. And there is the presiding judge, Judge Peter Stone, giving me a high five after he administered the oath of office to me. And behind him is my mom and my younger daughter, who in that image was 6 years old. And so began my journey as an elected judge to the Superior Court. I also want to ask you to put up the next image of hair. So hair is a theme in my life. And as you can see from these images, I had different hairstyles throughout the time I was on the bench. And the reason I raise it is, one, I talk about it in the first chapter of the book, but second, it's also about busting stereotypes. So on the picture at the very bottom in the middle, that's when I started out as a municipal court judge when I was appointed in 1982. And then it starts to get shorter, as you can see to the left. And then it gets even shorter on the right. And then as you go up to the top, you can see I had dreads, and then I had what's called a box with a fade. And it's just part of, I know my motivation was, I want to bust stereotypes and say judges can look like this. And the other part was because I just like wearing my hair in different kinds of ways. Okay, so back to elections. There are no federal elections of judges because they're appointed for life by the president. So we're really only talking about state court judges. Judicial elections were first instituted in the late 1770s and the early 1800s, when the then territory of Vermont and the states of Georgia and Indiana used them to fill seats on their lower courts. In 1832, Mississippi became the first state to adopt judicial elections for all of its judges. In the rest of the states at that time, governors appointed judges to lifetime terms, and I quote, during good behavior. So I want to read just a quick passage from the book. So let me just read you this. Today, 22 states utilize contested judicial elections. In the other 28 states, judicial selection methods range from merit selection, that's independent nominating commissions, to retention elections, yes or no votes on whether judges should remain in office, to gubernatorial appointments, to legislative appointments. When I ran for, we'll talk a little bit more about that in a second. When I ran for election, and that was in 1988, I raised about $70,000, primarily from lawyers, donations from about 800 lawyers. And that $70,000 is really a pittance compared to today's judicial races. So I returned to the book. Today, outside special interest groups pour money into contested judicial elections, particularly when Supreme Court seats are at stake. Why those courts? Because the highest of the state courts have the final word on how state laws are interpreted. According to the Brennan Center for Justice, 1/3 of all elected state Supreme Court justices currently sitting on the bench have run in at least one $1 million race. During the 2015-16 Supreme Court election cycle, political action committees, social welfare organizations, and other non-party groups engaged in a record $27.8 million of outside spending, making up an unprecedented 40% of overall Supreme Court election spending. Unsurprisingly, 56% of that money was contributed by lawyers, lobbyists, and corporate interests. So, and there's an even bigger problem with these elections. It's the impact that they have on judicial decision-making. Once again, from the book. Kate Berry of the Brennan Center for Justice analyzed 15 years of television advertising data for state Supreme Court elections to gauge the ads' impact on judicial decision-making in criminal cases. Generally, the ads attacked judges for being soft on crime or praised them as tough on crime. And let me just stop there. Nobody complains when judges hand down sentences of life or 100 years, but they do get complaints when they show mercy and offer sentences that many people contend are lenient. Let me go on. 3 of the key findings were: 1, the more frequently ads aired during the election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama imposed death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. Judges are not politicians. Politicians make promises to voters to appeal to whatever it is that their constituents want. That's well and good. But unlike politicians, judges are independent. The only promise that judges can make is to adhere to the rule of law, to legal principles, and to constitutional precedent. Judges are held accountable, not by elections, in my view. They're held accountable by the appellate courts who review their rulings and their decisions, by disciplinary bodies and commissions, and by properly run recall elections. And I'll get to that in just a second. It is my view that judicial elections should be replaced entirely and replaced with independent nominating commissions that are bipartisan, they're appointed by diverse stakeholders, and that they include non-lawyers. They have clear criteria for vetting candidates. And the nominating process by these commissions should be open and transparent with publicly available data about the diversity of applicants and nominees. Now, we have something like that here in California. It's called the JNE Commission, JNE, standing for Judicial Nominations and Evaluations Commission. And I just read one quick passage about that commission. And 16 states already utilize this approach, so we know it works. However, in 2 of those 16 states, Maryland and California, their governors can ignore their commission's recommendations and choose someone not on the list of nominees. That practice should end. Governors should stick to the nominee list. Otherwise, these commissions are simply window dressing. In my view, until we rid ourselves of judicial elections, we need to do a better job of educating voters when these elections come up. And I can't tell you how many times I've gotten these late night phone calls the night before ballots have to go in from my neighbors asking me who they should vote for judicial races. They don't have a clue. We need meaningful voter guides as long as we have elections that include detailed profiles of the judicial candidates, including any of the results of evaluations by lawyers that are occasionally conducted by the courts. I also think that lawyers seeking appointments to the bench, these are folks who want to be lawyers, should be required to audition for the job, serving as judges pro tem so that they can be evaluated by nominating commission members who are there to observe him. And I include that as some of the recommendations in the book. All right, the final topic I want to discuss is judicial independence. In a chapter titled J'accuse, Judges Under Attack, I began the chapter with this. There is frequently no warning or signal that a judge's decision is destined to blow up in her face. It could be her umpteenth sentencing decision in her umpteenth criminal case, but for whatever reason, one decision takes on a life of its own with disastrous consequences. That's what happened in Santa Clara County Superior Court to Judge Aaron Persky. So in 2016, Aaron Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman, a college graduate. Both were at a fraternity party and both were highly intoxicated. A jury convicted the student who, before he was even charged with the crime, had been expelled from Stanford. After Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. He became the target of a recall campaign coordinated by a female Stanford law professor who was outraged that the judge had not imposed a state prison sentence. What the recall deliberately ignored was that the punishment handed down by Judge Persky included ordering the student to register as a sex offender for the rest of his life. Convicted murderers who have served their sentences are not required to register as murderers for the rest of their lives. This student's punishment was harsher than that of someone who had taken somebody else's life. And before the recall campaign was over, the name Persky would become infamous throughout the country and beyond. Recalls of judges are unique to the states. Federal judges cannot be recalled, no matter how controversial their decisions. The California Constitution allows for the recall of elected officers, including judges. All that's needed is to collect the required number of signatures of registered voters in the county, if it's a judge's election, or of the state, say if it's a governor, to place the recall on the ballot. And you don't have to have a reason at all to recall the person. Simply disagree with the judge's ruling, she can be targeted for a recall, even when that ruling is entirely lawful. So I became a spokesperson on Judge Persky's behalf in opposing the recall. This was after I had left the bench and he was serving on the same court that I had served on. I spoke up because the recall campaign lied about the judge's track record. I spoke up because the sentence he imposed was within his discretion and entirely lawful. And I spoke up because the judge was not legally permitted to speak about the case. Judges had, before this recall in California, no right of self-defense. And I spoke up, most importantly, because the recall was a threat to judicial independence. So again, returning to the book, it's one thing to recall a judge for an act of malfeasance, but it is quite another thing to recall a judge for making a lawful decision that we don't like. Think about it. Judges take an oath to defend and to bear true faith and allegiance to the Constitution. But today, a judge can lose her job if, in defending the Constitution and bearing true faith and allegiance to it, she renders a decision that happens to be controversial. Putting the judicial finger to the wind to gauge public opinion is fast becoming the standard for judicial decision-making. And when that happens, when the cacophony of the mob determines how judges decide their cases, our independent judiciary becomes our dependent judiciary. So what are we to do? How do we ensure that our state court judges maintain their independence? This is a serious issue because if we lose our independent judiciary, which is one of the three legs of our democracy, executive, legislative, judicial, if we lose our independent judiciary, we lose our already fragile democracy. So the answer that I propose in the fix is to strictly limit judicial recalls to instances of judicial malfeasance or failure to perform duties of the office, or to judges who have been convicted of serious crimes. That is the way recalls of judges are done in Georgia and Montana. Recalls in these two states can never be based on a judge's lawful decision, be it discretionary or based on a judge's, or it's mandatory, no matter how controversial decision, as long as it's lawful. The revision of California's recall system would require an amendment to the California Constitution. And if our legislators won't take the lead in changing the recall law, then I think we, the people, the voters, could do so using the initiative process. All right, so I'm going to wrap it up now and just cover just two more things very quickly. One is the subject of race, which runs throughout the book. Obviously, my being the first Black woman judge appointed in Northern California. So let me just read you two quick passages on it, and perhaps we can have conversation afterwards. Race has always been the elephant in the courtroom. With the murder of George Floyd in May 2020 and the dramatic rise of the Black Lives Matter movement, racial disparities, long apparent in criminal prosecutions, sentencings, and incarcerations across the country, are finally front and center in the public discourse. The elephant has exited the courtroom and entered the world stage, giving to judges not only permission, but also the obligation to call out the legal system's failings. And this, my tenure on the criminal court bench was a conflicted one. By simply donning my robe, I knew that I lent legitimacy to a system that disproportionately targeted people of color. The majority of cases over which I presided involved defendants who looked like me. My presence on the bench gave defendants of color hope that they would be seen not as a bunch of gangbangers, thugs, and drug addicts, but as human beings. And it would allow for the possibility that many, perhaps most, were better than the worst crimes they had ever committed. One of my life's sad recognitions is that it is far easier to understand the humanity of even the most egregious of offenders when that person resembles you, less so when she does not. Finally, I want you all to understand that there is much that is good about our legal system. The very principles that are the foundation of the system and our nation are the best in the world. Principles such as all are created equal and entitled to life, liberty, and the pursuit of happiness. Everyone has the right to a speedy criminal trial, a right to a trial by jury, right against self-incrimination, and the right to due process. The problem is in the implementation of these principles. The propertied white men who established these principles, many of whom owned people who look like me, did not contemplate that these principles would apply to women, to poor people, and to people of color. Our challenge is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly to all. So in closing, before I have my conversation with Noah, I leave you with my conclusion in the book. Judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believed to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary. Hopefully, neither will you. Thank you.
Thank you, Judge Cordell. Inspiring words. Before we get Noah on and continue with the program, I just want to make one or two notes about your upcoming events. Let me show this real quick to our viewers. We have information that you will be appearing here, let me get this. I'm sorry, I'm futzing around with my screen here. That you're going to be in Marin City, appearing with or at the Marin City Library on February 27. Hopefully,
no, that's I'm going to be at the Sausalito Books by the Bay, and that book event is in part sponsored by the Marin City Public Library.
My mistake. Okay,
No
so that's in the flyer. I misinterpreted it. So you're going to be at the Sausalito Library, sponsored by Marin City Library. Again, is that still on February 27?
No, I won't be at the library. I'll be at the bookstore.
Sorry, the bookstore.
Right.
I'll get it right. Sausalito Bookstore, sponsored by the library.
There you go.
February 27 at 4 p.m., right?
That's a Sunday, correct.
All right, and you will be signing your book. So
yes.
Let me close out the screen share on that. Again, I got to get to the right screen here.
All right, take your time.
Sorry, this is just, you know.
And that's the cover of the book.
There is the book. There you go. Okay. All right, so are we back? Yes, we are. Okay. Sorry for all the glitches here, folks.
No problem.
We're going to go on, and it is now my pleasure to welcome back to our podium a man who needs no introduction, friend of the Marin Coalition, Mr. Noah Griffin. Noah is the newest member of the Tiburon Town Council, having been elected in November out of a crowded field of candidates, where he won by nearly 20% of the vote, more than the next highest candidate. He's been a fixture of Bay Area politics, arts, and culture his entire life. A graduate of Fisk University in Nashville, he earned his JD from Harvard Law School, I've heard of that. Before embarking on his several careers, he served on the staffs of Mayor Frank Jordan in San Francisco, Senator Dianne Feinstein, and Charles Schwab. He's hosted talk radio shows on KGO, KFRC, and K101. He's written op-ed pieces in numerous publications and served on the editorial boards of the San Francisco Examiner and the Marin Independent Journal. He's written for the Boston Globe and appeared frequently in the Marin Independent Journal, where he served on that editorial board, as I mentioned. His artistic career included the San Francisco Boys Chorus, the San Francisco Cosmopolitan Opera, the performances with Paul Robeson, Leontine Price, Johnny Ray, Nat King Cole, and many others. He founded the Cole Porter Society, which he directs with his wife, Meredith, and it gives me great pleasure to welcome back to our podium and hand the program over to my friend, Mr. Noah Griffin.
Thank you very much, Scott. I appreciate that generous introduction. Judge Cordell, you hardly give me any room to ask any questions. You were so thorough in what you did, but I thank you for writing the book. I think it's one of the most clear, lucid, straightforward assessment of the judicial system I've read. And to my mind, it should be required reading for every student in the country. Just some basics, if I could, please. Would you, for those who are non-lawyers, talk about the delineation between what the judge does and what the jury does?
Sure. First, Noah, thank you so much. I feel like I want to interview you. I mean, I'm serious. I am serious. So one day, and thank you for reading the book, and thank you for your kind words about it. So what trial court judges do and what juries do. Sometimes trial court judges do what juries do, but let's talk about the jurors first. So when there is a jury, the purpose of the jury is to be the fact finders, to determine what exactly happened. And I'm going to focus primarily on criminal cases. We have juries in civil cases too. And it's the same thing. The purpose is you're the fact finders. You are to listen to only to evidence that is presented in the courtroom, to listen to witnesses, to watch them, to assess their credibility. And then the jury operates by consensus. You go in as individuals to deliberate, but then you're also to talk it out and see if you can arrive at an agreement. In my chapter in the book about juries, I call Thank You for Your Service, I write about jury misconduct, where jurors are told clearly by the trial court judges, you do not go look things up or do your own research. And yet there are jurors who continue to violate those rules and think they can get away with, and usually they don't. And then the job of the jurors, once they've determined these are the facts, is then to apply the law that the trial judge gave them to those facts to arrive at a verdict. And those laws come in by way of jury instructions, long jury instructions that they have to go through and kind of match up the facts with what the law says, and then come out with an outcome. And I say
you write those down, do you not?
Yes, the jury
So that they can
instructions.
take that in with them to the jury room.
Well, that's interesting because there are in some states, the jurors are not allowed to have the written instructions in with them, which is bizarre because that's the law. And these are lay people who generally don't know what the law is. But sometimes judges are the fact finders as well as applying the law and arriving at verdict. And that's when you just have a trial in front of a judge only. So sometimes trial judges end up doing that.
Now that happens in juvenile court, correct?
In juvenile court, correct, there
Right,
are
now
not juries.
Let me let you elucidate for the benefit of those who are tuned in. You do not even have to be a law school graduate, to be a juvenile judge in so many states. And talk about the impact of that.
All right, so first, and I have a chapter in the book that deals with these cases, juvenile trials. So we have two types of juvenile courts. We have delinquency, that's kids, young people under 18 accused of crimes. And then there's dependency, where kids are the victims, where they are the subjects of abuse and neglect, and judges decide where they should be, foster care, or put up for adoption. All right. So we're talking about delinquency side. So there are no juries, generally speaking, there are no juries. It is a judge who hears everything. And in fact, the US Supreme Court has said that's okay. In fact, has given its stamp of approval to having just judges decide whether or not juveniles have committed felonies or misdemeanors. I take issue with the Supreme Court in the book and say that they are doing magical thinking. And I believe that juries should be allowed when juveniles are charged with felonies, where they're looking at having a felony record and serving time up to the age of 25 years in most states. So in some states, and it used to be the case, and it may not be the case today, but I do talk about in the book where some juvenile court judges had no law degrees. They were just kind of people that managed to get themselves appointed to preside over these cases. I think today, it would be hard pressed to find any states that do that now. But the key is when a 16-year-old juvenile is charged with a serious crime, and then you have a 18-year-old, or just a year and a half, 2 years, is tried in adult court because they're adults with the same crime, that juvenile in adult court is entitled to a trial, a jury trial. But the juvenile who's tried in juvenile court, the same kind of crime, the same crime, does not have that right. And I think that should change. And that's one of the things I recommend in the book, that juveniles should be allowed the right, the option to have jury trials if they're charged with felonies. And that is the case in some states today.
There's some other things that you talk about that should be up for change, and perhaps have been in some ways. 3 strikes law and its disproportional impact on people of color. Please talk about that.
So we have what is commonly known as the mass incarceration of people of color. And the contributor to that, what made this happen, is mandatory minimum sentencings. And before that, of course, people had to be charged with crimes under laws that required mandatory minimum sentencing. So what does that mean? It means generally trial court judges, when we get a case and we have to sentence, we have discretion. We have a range of time we can impose. Let's say the person is going to prison, but we have what are called minimum, mid, and the maximum levels that we can look at. And we look at various factors. That discretion is completely taken away with mandatory minimum sentencings. And that's what the 3 strikes law is. And it is done in several states. California most recently revised its 3 strike law because it was the strictest, most harsh 3 strike law in the country. So the problem is that mandatory minimums paint all defendants with the same brush. So we don't care if you had the worst childhood upbringing ever, if you were abused, we don't care if this is your first go round. If you're charged under these, you get treated the same way as someone who is an habitual criminal. And it takes away all discretion. And as a result, we have people, particularly if we just look at California, in our prisons under the 3 strikes law, the vast majority, more than 80%, were serving time where their 3rd strike was for a nonviolent, non-serious crime, meaning either thefts or drugs or both, and not serving time where their 3rd strikes were for violent offenses.
Now, there are pluses and minuses to plea bargaining. I'd like you to explain to folks what they are.
I have a chapter in the book that deals with plea bargains. And so what is a plea bargain? Plea bargain is a deal. It's a bargain. If you're charged with a crime and prosecutors engage in what I call overcharging or piling on, they will charge you, you're charged with 6 crimes, and they're only interested in counts 1 and 2. They're not interested in counts 3, 4, and 5, but they pile them on. And basically you're left with a deal. Says, look, you want to make a deal? I'll dismiss counts 3, 4, 5, and 6 if you plead to count 1 and 2. And that's the bargain. And if you do that, you don't take the risk of going to trial and get convicted of all 6, where you get a real long sentence. In this case, it's just counts 1 and 2. 98% of all criminal cases in this country, in the federal system and in the state system, are resolved with plea bargains, 98%. So there's a lot of that going on. And so what's the problem with it? Well, the problem with it is, one, they tend to be coercive, meaning people feel that I have to take this bargain because I've been overcharged. So you have this coercive nature of plea bargaining. Now, in some instances, plea bargain is fine. I mean, sometimes we don't want victims to have to go through the trauma of going to trial and having to testify and relive awful things. So in that respect, plea bargain is a good thing. But in many instances, that is not the case, where you don't have victims who are going to be re-traumatized, but you have people who are being coerced. But there's a second issue, which is, I think, a very grave one, and that is what I call in the book the innocence dilemma. The US Supreme Court has said, you know, it's fine if you claim you're innocent and you still plead guilty, that's okay. The US Supreme Court did this in the case of, it's the Alford case, and Mr. Alford pled guilty to murder. And he pled guilty to 2nd-degree murder because the deal that was offered to him was, if you don't plead and go to trial and convicted of 1st-degree murder, you're looking at the death penalty. So in order to not do that and not take the risk of going to trial, he said, I didn't do it, but I'm going to plead. He then appealed, and it went eventually to the Supreme Court that said, if there is overwhelming guilt of the person, it's okay if they still say, no, I didn't do it, and plead, even if they claim their innocence. So Alford pleas have become a very large part of plea bargaining. Now, if you notice, I said, if there's overwhelming guilt. So what's the loss? You're claiming you're innocent, but there's overwhelming guilt. That was the Alford case. But it has turned out that Alford pleas are being utilized quite a bit throughout the country, where people are claiming they did not do it, and there is not overwhelming guilt, but those pleas are going forward anyway. And why do we know there's a problem? Well, we have this thing called exonerations, where people who pled guilty, claiming they didn't do it under Alford, have been found to have been innocent and been exonerated. So we have the innocence dilemma. And in the book, I write about a study that was done by 2 researchers who looked into this whole effect. Why would somebody plead if they're innocent? Why would they even do that? And so it's a very interesting study that they did with college students. And they tried to replicate a system where students were accused of cheating and faced some very severe consequences, and they hadn't cheated. And they were given an option. If you just admit that you cheated, then you just get off with maybe a hand slap. But if you decide you want to contest it and go before a board of faculty members who generally find 90% of the people, in fact, did do what they're accused of, go ahead and do it. Well, they found that a surprisingly high number, and I don't know if it was 90%, said, okay, I cheated, and they didn't cheat at all. And they use this as an analogy to say, this is why people will sometimes do this. So I have a problem with a criminal legal system that pressures people into pleading when they say they're innocent. And then finally, the third thing, trial judges get really ticked off when they find out that the person coming in for a trial refused to accept a plea bargain. And I have heard judges have said, okay, you want to have a trial here, that's fine. You didn't want to do the plea bargain? Okay. So now if we go to trial and you're convicted, I'm throwing the book at you. And it's today called the trial penalty, which is completely wrong, should not happen. So the Sixth Amendment says everyone has a right to a speedy jury trial and not to be penalized for it. But that's not what's happening in our legal system.
Let's flip this around. Somebody like Bill Cosby said in depositions, I'm guilty. But then he comes out and says, oh, I'm innocent at trial because they gave him a deal. You admit to what you do here, and then we're not going to bring that up again at trial. So how does that work?
Well, it's a little bit different there. So Bill Cosby, and it was state court, it was in Pennsylvania. So he agrees to testify in a deposition because he was being sued. And the deal that was made with him was that if you just tell the truth here, we won't use it in a criminal prosecution. That was the deal. He accepted it. He, quote unquote, told the truth. And then another prosecutor comes in and changes the rules. So the Pennsylvania Supreme Court said, you can't do that. If you make a deal, you can't go back and change it. That decision by the Supreme Court that reversed his conviction, that vacated it, is now on appeal in Pennsylvania. I don't know what the status is at this point, but it is being appealed by the prosecutors.
Getting to some generalities here, why should poor people and people of color even trust a system that disproportionately disrepresents them in the sense that they're more frequently arrested, charged, found guilty, sentenced, and imprisoned longer than their white counterparts?
So you've asked, the question, which is trust in our legal system. If we don't have people who trust it, you won't have people who respect it. And if you don't have people who respect it, you have people who just have no stake. They have no stake in anything. So why should they comply with any of the rules? And an analogy, research has just been concluded about vaccines, about COVID. And they found that states and countries that did the very best in terms of getting people vaccinated where people had real trust in government. And where there is lacking trust, people just say, oh, I'm not going to abide by these rules, whatever these mandates are. I don't trust it. So you've asked an important question. Why should people who come out on the short end of the stick have any trust and faith in our system? And it goes back to inclusion and representation. If I see people who are sitting at the helm in the legal system who look like me, who have had experiences like me, I am more inclined to trust that system. So the more that we can be inclusive, the more that we can have representational diversity, and I'm not talking tokens here, representational diversity, that's how we build trust. So I don't fault people who go into systems where they don't see people like themselves for being skeptical about it and not really wanting to trust it. So we have a lot of work to do to bring in that inclusion.
Well, if you're looking at, say, the Supreme Court, do you have a court that represents America? The 115 justices, 9 have been Protestant, 15 have been Catholics, 8 have been Jewish. You have 2 Blacks, 1 Hispanic justice who's Puerto Rican, 6 of them from Harvard, 3 of them from Yale currently, and currently 7 Catholics or have Catholic roots. So how can we say this is a court that represents America and also ideologically? You talked about the 3 independent branches of government, the judicial, the legislative, and the executive. It appears to many people that the Supreme Court is just an arm of one part of the executive or a political party. mean, how do we disabuse people of that when it seems these decisions that are coming down have a more political taint than not ever in our history, because I know we've had bad times in our history, but it seems that way currently.
Well, I think what you say seems that way is actually that way, and it saddens me very much. So if I just focus on the US Supreme Court, and the whole process, for example, of nominating Supreme Court justices, it's always been about identity and politics. And it's just been that for nearly the first 2 centuries of the court's existence, the only people considered for inclusion were white men. And so it has become that white men are the norm against which all others are judged, which is why everybody goes into conniptions when it's mentioned that we want to put the first woman on, and we want to bring on a Latina, we want to bring on a Black woman. There are those who just react and say, oh, no, 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 you're bringing identity politics into the court. It's always been there. What I say is that inclusion is the key. And I don't care where you are on the political spectrum, if you're very conservative or very liberal, I don't think any reasonable argument can be made against inclusion. And so inclusion is what is definitely needed on our Supreme Court. The way it looks, it does not represent America. And it is important that that representation be there for the very reason you brought up earlier, Noah, about trust in the system. So I'm feeling very good that President Biden has decided to go in the direction of bringing on the first Black woman on the court. It is long past overdue. And I know we'll get someone, I'm hopeful that we'll get someone who will reflect the experiences of what Black America is and has undergone. I mean, that's exactly Thurgood Marshall. I mean, his whole history was that Thurgood Marshall, he spent his life in the service of and for the liberation of African Americans. And that was reflected in the work that he did on the court, and he did wonderful work. Nobody has criticized that. So that's my hope in this process.
It was, I think he won 29 of 32 cases before the Supreme Court, 9 out of 14 as Solicitor General. Wow. Never once reversed on the Second Circuit. I did the McNeil-Lehrer NewsHour twice. I did it when Clarence Thomas was nominated. And I said, well, I'm just going to speak my mind here. And I talked to Jeff Brown, who's then the public defender of San Francisco. He said, fellow's pretty much like a quisling, isn't he? I didn't know what a quisling was. And I looked it up and I used it that evening. And wow. I said that I had gone too far. But I talked to him for an hour and a half once he'd made his decision in the Michigan case, another case. And he said, well, I said, why'd you rule that way? He says, well, there are 5,000 elected officials who said, we don't need these rulings any longer, especially gutting the voting rights case. And now he's the 5th vote in most of these cases that go against either keeping the rights that we already have or expanding the rights to where they should be. And it's an embarrassment, particularly, it gets back into a question about recusal. We have a situation where his wife, as I understand it, was given $240,000 to a side that has a case before the Supreme Court, and also paid $80,000 to pay for a bus for people to go to January 6th. It's an embarrassment. Why don't the rules of recusal apply for Supreme Court justices as they do for justices in lower trial courts?
So, and I mentioned this in my book, state court judges have what are called codes of conduct. They're the rules that you don't, certain things you can and cannot do, including recusal, meaning if there's a conflict of interest and it's either a real one or even it's an apparent one, it just appears that way, then you back out because we want people to trust the system. And we have disciplinary bodies that discipline judges when they don't do the kinds of things like recuse themselves. The US Supreme Court has no disciplinary body, and it has no codes of conduct. So they just police themselves. And it is past time for there to be a disciplinary independent body that looks at the conduct of federal judges and including the US Supreme Court judges. But right now it is all internal. It's no transparency whatsoever. And recently, there has been a request coming from Congress that there be some sort of code of conduct for federal judges in including the US Supreme Court. But right now there is none. So they just can do whatever they want to do and without any reprisals because they're there for lifetime tenure.
As a result of that, do you think there should be term limits? And do you think there should be a court expansion?
I think the court should be much larger than what it is. And I also believe that there should be term limits. There should be staggered. There should not be these lifetime appointments. I mean, we've seen what the selection of judicial nominees look like now in the Supreme Court. And it's a game that's being played. And people right now, the most recent polls show they have the lowest level of trust in the Supreme Court, what it does and its decisions. We need someone to pull back, individuals to pull back and look at this whole process. And I think we need major, major changes.
Does the American Bar Association still have to weigh in on the qualifications of all the judges and the impact of the Federal Society vetting some of the
Yes.
judges?
Right. So there's two things. There's the American Bar Association, which is the group where lawyers join it. And then the ABA has a special section that looks at and has historically evaluated judicial nominees to the federal courts, all the levels, and the US Supreme Court. And so they don't have to do it, and the president doesn't have to utilize their evaluations, but they always have until Trump was president, and he just completely ignored their recommendations and their ratings of judges. And that's what they do. They rate them: qualified, very qualified, not qualified. The Federalist Society is a conservative organization that compiled a list of federal nominees, nominees for federal courts, and that was used exclusively when Trump was president, to just take from that list. They can do that. There's nothing that stops the ABA from evaluating or from the Federalist Society to doing it. But you see what the system has become. These names percolate up, and if it's from a very conservative group, it goes to a president who wants to make very conservative nominees. And I find that sad. I mean, we need a variety of views on our federal courts. We need people who think differently about different issues, but also adhere to the law and not seek to just ignore precedent. And that is concerning right now.
How can judicial bias be screened for?
So in the book, I write about bias. Judges are human beings. Every human being on this planet has biases. We all do. And for everyone to say, oh, I'm not biased, I don't have any biases, they're lying, or they have no kind of self-awareness or introspection at all. So judges, of course, have biases. And the problem is when those biases come into play, and let's just talk about sentencing, when they're, or even just presiding over trials and cases, how their attitudes toward women, or attitudes toward people of color, or attitudes toward LGBTQ. If these biases surface, then they color the decision-making, which should be as independent as possible. So how do you test that? Well, I mean, there are various trainings and courses that judges can opt into. Some states require this kind of training. I taught at the Judicial College in California. It's at Berkeley. And I taught the course on bias and on judicial conduct. And so that's all fine and good. But the key is the judges themselves have to understand what their biases are and then become aware of them. Because once they're aware, we hope they're the kind of people that say, oh, I'm aware of this bias. Now I need to put it aside and look at things. So I have told some judges when I taught, here's what you want to do. You want to test if you have a bias? I want you to do it, to flip it. So if you have a woman in front of you that you're getting ready to sentence, make that woman a male, same color, whatever, but same age, same conduct. Would you impose the same sentence? If on the same facts you would not, then you need to reassess. Same thing with race. You got somebody Black in front of you. The sentence you're imposing, what if that was a white female or a white male? Same identical facts. Would you do the same thing? And if the answer is no, then there's the bias surfacing. So it's there. It's something we have to work at. And we know there's bias in the system because just look at the numbers. The numbers don't lie. The number of people of color and poor people who are incarcerated, who are prosecuted, the length of sentences, all of that is now fair game to talk about. It's been there, but now it's up front and we need to deal with it.
Scott has been very kind and not stepping in here. I have one last question before we open it up to the audience here. While in law school, too often I saw classmates who had the privilege of prep school education, Ivy League undergraduate degrees, attending similar East Coast elite schools, clerking, working for prestigious firms, professorships, becoming judges or jurists without any real connection with the majority of people the decisions would impact. How can we break that cycle? Your thoughts?
So we're talking pipeline here. We're talking about from the very beginning, how do we get people who have been previously excluded from participation in our legal system in a variety of ways in? And one group that has been excluded for years, women, and then specifically Black women. So it's been we got a delayed entry into the legal system, and there are now more Black women coming into the profession. So we're talking pipeline here, and it's about figuring out ways to creatively reach back to kids in middle school, in high school. I've spent time in classes in high schools, getting people just interested in the legal system, but getting young people to see somebody who looks like me, who's saying, you know, I've done this stuff. There's no reason why you can't. So it's really a pipeline issue. We have a group of Black judges in California that are really working really hard to reach out to communities of color. So it's not going to be solved overnight, but things are happening, and we have to just keep pushing and never accept that you hear a law firm, well, you know, we've looked and we just can't seem to find people. I just say that's total BS. You haven't worked hard enough. People are there, and we just need to do the work.
Thank you, Your Honor.
Thank you, Noah.
Thank you both. And please stay with us. And we're going to go to our audience questions now. And those of you who have questions, as we mentioned, put them in the Q&A. I've been watching as you've done that already. Questions for either one of our panel members here, and we will pick them up and bring them to the fore. And let me start with a couple questions, basically the same question on a technical matter. A couple of our viewers have asked, in light of some of the perceived misconduct of judges or questions as to their integrity, isn't there an impeachment procedure that can be used for not just federal judges, but also U.S. Supreme Court justices?
So impeachment is the only remedy for removing a federal judge. It is the only remedy. And judges, there have been, if I recall from my reading, maybe 2 or 3 instances, it's in my book, where federal judges were impeached and actually removed. So we know that impeachment has been brought, Bill Clinton, Trump was impeached twice, but the voting then is, an impeachment is really a trial to see whether or not this person engaged in misconduct. So yes, that is the only remedy, and that has to be done in Congress. It starts in the House, and then it ends with the Senate, and it's the Senate that just really decides whether or not the person should be removed.
And that can go all the way up to the top, the U.S. Supreme
Absolutely,
Court.
sure.
And along those lines, I read recently a very interesting article concerning the wife of Justice Thomas. I don't know if you happen to have caught it, the Jane Mayer article in the New Yorker, where she goes through and she describes the personal connections and the financial connections and the political connections that one of the justices' spouses has in a sector of the political realm. And that's the same sector that has issues and cases and matters that are pending before her spouse's tribunal. To me, it was a very disturbing article. I don't know if you've got any thoughts on that.
Yeah, and Noah raised it a little bit earlier. How can we trust a system that allows a justice to sit and decide cases in which his spouse has expended lots of money and has been very vocal about supporting a particular view? That is classic, where the justice should say, I can't preside over this because I'm too close to a person who has a vested interest in this. And that has not happened, and it isn't going to happen. And unless, I think, if there's a sufficient public outcry from people, perhaps then the court itself will say, we need to, Justice Thomas, you need to step aside and not preside over issues that involve any of these things. I don't know if that will happen. It's doubtful given what the majority is on the court. I still think it's important that people speak out about this. And I hope that others, the journalists, continue to focus on it. I think it's outrageous, and it undermines and further shows why, it undermines the court and further shows why people are lacking in trust in that institution.
And one of the issues that was so interesting to read about in that article was that in the view of some of the critics of Justice Thomas in that instance was the difference between an actual conflict and the appearance of conflict. There may or may not be an actual conflict if someone's spouse is involved in a political activity that's before the court, but there's certainly an almost undeniable appearance that there could be a conflict there.
Exactly. Yeah.
So that actually, I use that as a wind up for one of our audience's questions here about two particular cases, not Supreme Court cases, at least not yet, but Brent Miller asks about an article that he recently read in the journal Verdict, which was written by Jeffrey Abramson. And he's talking about, in the article, the article talks about the difference in the conduct of the trial judges in the Kyle Rittenhouse case, as opposed to the judge who presided over the case of the three individuals that were charged and ultimately convicted of the murder of Ahmaud Arbery. Very different demeanor, different way that the case was handled, different rulings in terms of some of the procedural issues. So here's Mr. Miller's question. Jeffrey Abramson argues in his article in Verdict that judges have the power to control trial outcomes by their actions, making facts and reality less important than it seems they should be. If that is the case, how is it possible to believe that states can ensure that each person will receive equal protection under the law? Should something change, or is Abramson wrong?
Abramson is not wrong. I have a chapter in the book called Bad Judges, where I talk about judges who engaged in misconduct and what happened to them. If I had written my book a little later, I would have included the judge who presided over the Kyle Rittenhouse trial in that chapter. His behavior, both verbal and non-verbal, was atrocious in my view, and tainted the trial, influenced the jury, which trial judges are never supposed to do. In the book, I write about a study. I was one of the co-authors of the studies, the first study ever done on judges' verbal and non-verbal behavior in presiding over trials. And what we found was that verbal as well as the non-verbal, which was very interesting, had tremendous influence on jurors. The jurors are, and I found this when I presided over trials, were always, I'd look up and I'd find a juror or two just looking at me because they're reading me. They're trying to see, what does the judge think about this witness? Or how is the judge perceiving, this evidence? And what that judge did in the case was his rulings were clearly biased. He yelled at the prosecution. He was very kind to the defense who represented Kyle Rittenhouse. He put himself physically in close proximity to Kyle Rittenhouse. There's this photo of Kyle leaning over to look at, I don't know if it's looking at some evidence, and he's right close to the judge who is right near him. Their shoulders are almost touching, sending a message to the jurors that the judge really likes this young man. And I found it atrocious. And then we find the opposite conduct in the judge who presided over the trial of the three men who murdered Ahmaud Arbery. I say that every person has a right to make a complaint against the judge. So I have encouraged people to file complaints, and some people have right here from Palo Alto against the judge in the Kyle Rittenhouse case. Because once a complaint is filed, every state has a disciplinary body that has to investigate complaints. So I don't know what has happened there, but it's important for people to read that chapter where I wrote about bad judges. And also, I have an appendix that's not in the book, but if you'll notice in the front, there's a link to where you can go. I didn't want to have a tome full of appendices, but I have links in the appendix to every disciplinary body of judges in every state, by state. So if you want to know, and you go on it, you can also read about judges who have been disciplined in every state, what it is they did and what the discipline was. So it's really important to understand we have power to do something when we see this kind of misconduct by state court judges, not so with federal judges.
This actually leads into another question we have from one of our viewers. Martin Malkin asks, I think it's interesting that this question came in light of what you're saying right now about the conduct and the impression that judges give to the litigants and to the public. His question is, wasn't part of the outcry regarding the sentence imposed by Judge Persky based on his comments during the sentencing? So here you're talking about a question of the recall of Judge Persky, and this question asks, wasn't that in part due to his conduct on the bench?
So I say, thank you for the question. There is so much misinformation about what happened at that trial and about Judge Persky. I don't even know where to start. It was an uphill battle to deal with the social media sound bites that were going out all the time about the trial, about what was going on in the courtroom, and about the judge, that there was so much that we had to deal with in trying to get facts before the voters. So I can't even begin, and I apologize because it would just take too much time to go through everything. And you know, in my book, I'm not writing about what Brock Turner did or didn't do. I'm not writing about the trial. It's about a judge who did what he believed to be right, a judge who followed a recommendation from probation, and for doing that, he lost his job, doing something that was entirely lawful. That is the focus. That's what I'm focusing on there.
Okay. Let me ask about, you're talking about juries, the abuse of peremptory challenges and unfair practices by counsel and perhaps even by judges in excluding certain members of the jury, thereby leading to non-representational jury panels. There's a question, you know, Noah, you might want to weigh in on this as well. There was recently a study done in, I don't know if it was just the Bay Area or California, but the outcome was that among other findings, one of the findings was that the county Marin is one of, if not the most segregated, racially segregated counties in the state. And I guess the question is, does that lead to impacts in terms of the makeup of our juries here? And if so, what, if anything, can be done to try to rectify that so that we have jurors that are more representational of the community?
Noah, if you want to jump in, and I'm glad to comment after you.
I've never picked a jury. They want to rule me out on drunk driving cases, which comes out a lot because I've been 43 years sober, and I want people to reach their bottom as quickly as they can. And you have some relationship to that, Judge, so I will defer to you on this one, please.
Sure. Our schools are more segregated today in this country than they were back in the 60s. And that's primarily because of housing. And the whole issue of housing and segregation has a long history and a sad history in this country. So when you tell me that Marin County is segregated, I'm not shocked by it. I'm saddened by it. And as a result, everything gets impacted. Our schools, how our kids learn, with whom they interact. And then if we get to the legal system, it gets impacted because of the demographics of the people running the system, and of course, our juries. The people who can spend time on juries generally can afford to do it. They don't have to worry that they're going to lose money or lose their jobs. They tend to be people who are retired and who can who have the time and wherewithal to sit on juries. We need more representationally diverse juries. One way to do it, I argue in my book, is to see that everyday folks can afford to sit on our juries. And as I stated earlier, California pays $15 a day. And there are folks who just cannot afford to take off work and be on a jury for a day, a week, or several months. There is no rule that requires big companies who use our courts all the time, Microsoft, Facebook, Google, all these big companies, Uber, Lyft, they are not required when their employees are called for jury duty to pay them their salaries the whole time they're on juries. That needs to change. So I recommend that in the book, that if we do compensate jurors or require big companies that can afford to do it, we will have more diverse jurors. We will have juries that look more like our communities. So there are remedies to it. And sadly, I mean, it ends up to allowing people who ordinarily would not have the means to do that, the financial means to do it, to be able to sit on our jury so that we have a cross-section racially and socioeconomically of people from our communities.
We have a technical question from Mary Beth Halloran, who asks, if a person fails to respond to an order to appear for jury service in California, is that order enforced, and if so, how?
A warrant will be issued for that person's arrest. And if you ever got one in the mail, it'll scare the heck out of you. And then that means you get on the phone and call and hopefully have a good reason for why you didn't show up for jury duty or to get yourself over to the court. And most counties now, those warrants do go out because we're now starting with COVID. There were not juries. The jury trials actually went on a hiatus because we couldn't have people sitting together in the jury. And even if they were there wearing masks, you have to, if you're a lawyer, you got to read your jury. You got to know, how they get a sense of them, and you really can't do it when they're wearing masks. So as things start to open up, more jury trials are going to happen. So if you do get a summons, that you do have a way out. I mean, you can be excused from jury duty. You can be excused if you have a legitimate reason to do so. But if not, don't ignore it. Just please don't ignore it.
Okay, we have just a few more minutes. I'm going to try and get in a few more comments and questions here. This is from Wandon Trianor. I hope I'm saying that right. Thank you, Judge Cordell. One comment, Judge Faye Dopal retired from the Marin Superior Court and ran for re-election in 2004. Hope I'm reading this right. We doubt, with her non-traditional educational background and lifestyle, that she would not, that she would have been appointed at that time. She was elected the only woman running against 7 white men. Same with Mary Morgan, Donna Hitchens, and Nancy Davis. We were all connected through New College. Sally Dixon, too, all non-traditional women in the law. See you at the bookstore, Wandon and Faye.
And I know almost all of those judges. So thank you for that comment.
Okay. Another comment here from Norman Nafach, if I'm saying that correctly. Norman, I apologize if not. Most civil cases are settled. It is said that the judicial system would not be able to operate otherwise. To what extent, if any, should that not be a consideration in criminal matters as well?
Cases, as I told you, most cases don't go to trial and the criminal side, and because of plea bargains. And without plea bargains, the system would implode, which is really sad when you think about it. So we are saying that the system, for it to work, has to deny all these people a right to a jury trial, because if they wanted their jury trials and had them, the system couldn't handle it. So we have to look at why so many cases are coming into the system. We have to look at what prosecutors are doing, if they are charging cases that maybe shouldn't be charged. This is a problem on a number of levels. Justice Kennedy, when he was on the U.S. Supreme Court, said of plea bargaining, he said, the plea bargaining is the criminal justice system. I mean, he acknowledged that. So I just see this system just veering totally out of control, where we have to say to people, push people to plead guilty who claim they're not, or even if they are guilty, they have a right to a jury trial under the Sixth Amendment, but we're saying basically we can't do it. So I don't have a ready-made solution for any of this, other than to first bring it to the attention of those of you all who care, and then to start thinking outside the box about what it is we can do to make some major changes so people can really appreciate what a right to a jury trial is.
Okay, let me squeeze in one more question. This is again from Norman. Is there real independence in the judiciary when judges are subject to the political process to keep their jobs?
Well, that gets back to judicial elections. And I believe as long as there are judicial elections and we have to lean on lawyers and other folks to give us donations so we can run a campaign and make promises, that's not an independent judiciary. I think that's the reason there aren't elections in the federal system. But that's the way it is in the state systems, and I want to see it end. I don't believe we can have an independent judiciary as long as we have judicial elections. We need to do other things as well, but that is a huge, huge issue.
Okay. I'm being told by Alan that there was an additional slide that we did not get up into the program. Alan,
Sure.
do you want to put
Go
that
right ahead,
up?
Alan.
I don't know if you're tuned in here or not. Okay, there we go.
So the reason I passed over to Alan is I think it's a little small. I don't know that people can really see it, but these are suggestions for reform that some of which we've already spoken of, that are in the book in much greater detail.
Okay, and I think that actually raises something that I'd forgotten to mention, but we can put up your slide presentation with the recording of this presentation when we do this on our website archives. So if that's acceptable, Your Honor, we'll
Absolutely.
Okay, so we'll put that up there. When you go to the website, you go to the archive page, and then you go down chronologically. In a day or so, we'll have it up. You can see on the website that this presentation, as recorded, will be there, and then there will be another separate link to the slides and the other material, so you can take a look at that on the website. All right, well, we are at the end of our time. I want to thank Judge Cordell, thank Noah Griffin, both of you, for sharing your insights and being with us today for such an important and interesting discussion. Once again, Judge Cordell will be at the Sausalito, Bay Area Books?
Bay by the Books. Books by the Bay, excuse me.
Books by the Bay, okay. In Sausalito on February 27 at 4 o'clock. You can pick up her book there, and she will be there in person to sign it. So that's a great opportunity. I think that's going to wrap it up for us. I want to thank
Scott, if I could just say one thing before you wrap.
Sure, please.
I just want to thank everyone. Thank you, Scott, for reaching out to me. Thank you, Noah, for engaging me in conversation. Alan, thank you for all of your help and support. And to everyone, I just want to leave you with the mantra by which I live. And I took it from Alice Walker. And it is this: let activism, let me start again. Activism is my rent for living on this planet. And I ask you all to pay your rent by living every day, doing something that will make this world a better place, be it in our legal system, be it in our business sector, in education, wherever it is. Please, please pay your rent. Thank you so much.
Cannot think of a better message to leave us with. In signing off, I want to thank Gary Baum for introducing us to Judge Cordell and making this program possible. And also to our webmaster, Alan Shavitz, for orchestrating another terrific Zoom presentation. That's it for us today. Don't forget, March 9, General Manager of SMART, Eddie Cummins, will be our guest. And we will see you back again here then. Thank you for tuning in today. Very important discussion. Thanks again to our presenters, and we hope to have everyone back. We'll see you next time. Thank you.
Bye.